Hello, and welcome to For Book's Sake. I'm Heather Roberts.
I am Veronica Adams, and we are 1852 Media.
And the sound, our opening song, just wanted to start immediately this time. Usually we get like a 2-second delay.
Yes, and
So if it was cut
apparently
off,
it
meh.
knows it's Friday. It's time to jam. It's an interesting week. Yeah.
Yes. And Veronica is joining us from sunny Florida.
Yes, I am currently on St. Pete Beach attending NINC as an industry guest, learning a lot, meeting lots of new people, having a great time.
Yeah. So getting
Yeah.
out there, we love it. And thank you for, fitting this in to your
Yes.
schedule down there because we could have skipped, but Veronica said no. No, we're going to do
I
this.
did. I am committed to the podcast. Also,
Yes.
we're recording during the lunch break and it's a Mexican buffet and I am currently on a restrictive diet that Mexican food is not compatible with. So, it's easier for me to be recording the podcast than it is watching people eat enchiladas.
Yeah, no, that makes total sense because that would be hard to resist.
Yes,
Very hard to
100%.
resist.
Yeah,
So, well, we appreciate your dedication on all
of
accounts.
course. Of course. Wouldn't miss it for anything.
Today, we are on part 2 of Cockygate.
Oh, Lord, have
So,
mercy.
yeah, if you've not been to, yeah, and this is once again,
Heather with her printouts from
yeah,
Pacer.
this is, oh, hold on. We have the actual transcript too. So, yeah, I can't help it. It's a thing. Okay. The
Yep.
paper gets recycled. Calm down. Um, but yeah, if you didn't listen to part 1, go back and listen to it. It'll lead up to where we are picking up today. Very
Yeah, you don't
brief.
want to dive into this shit show without listening to part one.
Yeah, I mean, that gives the whole background on who the players are
Yes.
and everything, what the environment was like. But the short version for those who are refusing to go back and listen is that Felina Hopkins, through Hop Hop Productions Inc., which we still agree is an adorable name for a company.
Yes.
Yeah,
Just
it's
absolutely
great.
nailed it.
Yeah, really good.
Yes.
Through Hop Hop Productions, sued 3 individuals for violation of 2 of her trademarks that she
That's right.
had that trademarked the term cocky for use in romance novels. And one
Mm,
was a word mark, one was a specific mark of how it looked on the cover of her romance books.
right.
And she sued Kevin Nupper. I don't know if I'm saying his last name right. I apologize if I'm
Probably.
not, but I believe there's a silent K. So Kevin Nupper, he's an attorney and author who filed a petition to uh,
Challenge
basically
the trademark.
challenge the trade. Yeah, thank you.
Yeah. Yeah.
To challenge the trademark. My brain stopped braining for a moment.
It's
Um,
Friday.
and then Jennifer Watson, who was the publicist of Cocktails, a Cocky anthology
Yes.
that was put together from all of the authors in the industry, a lot of large named authors who wanted to essentially raise money to help, ensure that creative expression still exists.
Yes. The money specifically, I think, was to be donated to the Authors Guild and RWA in their legal battle over the trademark itself.
Yes, and creative expression. That was like their big
Yes.
thing.
Yes.
And then Tara Crescent, who is an author and has released many books. The ones in which are mentioned here have cocky in the title. So,
Yes. The misfortune of using this same trend at the same time as Felina's trademark registration being approved.
yeah.
Yeah.
And so here we are in the United States District Court in the Southern District of New York. Just as a
Which seems
note,
like it's where everything happens, by the way.
yeah,
Can I just,
they don't play. Like, they do not play. And this case is a shit show.
from the
Um,
beginning,
from the
from the
beginning.
outset, it's just an
Yeah.
absolute, it's a roller coaster ride.
Quick disclaimer, Veronica and I are attorneys. We're not your attorneys. This is
That's
for
right.
entertainment purposes only and
Yes,
commentary. This is our legal opinions. Go get your own legal opinion.
that's right.
So
Absolutely not dispensing advice here, just
yeah,
editorializing.
100%. I'm going to editorialize a lot because this case, holy shit. Okay, it was filed on May 25th, 2018.
Yes.
If I recall, isn't that a holiday weekend? I need to go back and
Memorial
look.
Day.
I
It's
believe it's
Memorial Day
Memorial Day
adjacent.
weekend.
If it's
Yeah.
not the weekend, it is adjacent to it for sure.
I think it was filed now we're going to have
Do we
to
have a calendar we can pull up very quickly to just confirm?
yeah, I'm swinging back through. I believe it was Memorial Day weekend, and I'm just interested in what day of
2018.
the week that was. May 25th, 2000. That was a Friday.
Oh, what a bitch move. The Friday before Memorial Day?
Yeah, hold on, I'm pulling this up. Yeah, Memorial Day
That
was Monday.
that's some hateful fucking practice of law. I'm sorry. Excuse my
Yeah,
language. There's just like
I'm just double checking. Yeah, Monday
This
was.
is the kind of shit that gives plaintiffs' bars a bad reputation.
Mm-hmm. Yeah. So it was filed on Friday. They requested a temporary. This is Felina who's filing.
Yes.
Okay.
Her attorneys
And
filed a lawsuit to
yes.
proceed against the three defendants.
So they filed a complaint, which normal. Okay, you
Standard.
file a
Yeah.
standard. If they just would have filed the complaint on the Friday before Memorial Day weekend, fine. Okay, you do whatever. You file
Yeah.
that whenever the hell you want to file it. But they also filed a preliminary injunction and temporary restraining order.
Hmm.
And the court initially grants that for like 2 seconds, like literally. I think it was like less than 24 hours,
Yes.
grants it on its face. And then, after reading the defendant's petition for cancellation before the
Mhm.
trademark board
Yes.
and reading the plaintiff's motion and supporting papers, they quickly decided to dissolve the preliminary injunction.
And set an evidentiary hearing.
Yes, and set an evidentiary hearing
Uh-huh.
for June 1st.
So
Okay.
literally just a week after the complaint is filed. So this is a lot
Yes.
of action in a lawsuit at first, especially in federal court.
Right.
Um, this is a judge who is taking this very seriously.
Yeah. And, when you're filing a preliminary injunction, you're basically saying, hey, judge, I have an emergency here.
That's right.
We are going to be harmed, like
If you don't
unbelievably so,
prevent this
if you
thing
don't.
from happening,
Yes.
or compel this thing to happen. Sometimes
Right.
it's compulsion rather than restriction with the
Yeah.
injunctions and the TROs and stuff. So, yeah.
And the court is oftentimes very, receptive to that, and they're very respectful of that. Okay,
Mhm.
this is an emergency situation. Okay, so they initially granted that and said, okay, you can't. Basically, it was to prevent the publication of cocktails. Let's be honest. That's
Right.
why it was
Right.
filed when it was filed.
Yes.
Cocktails was scheduled to be released. I believe it was the Tuesday, so that would have been May
The 29th.
29th. And the court granted the temporary injunction, and so originally they thought that they were going to have to halt the release
Right.
of
Right.
cocktails, but then on the 29th they rescinded that. So yeah, here we go.
Yeah.
So, and then cocktails was released,
Yes.
and we know what happened there. The court seemed, the court seemed a little annoyed by cocktails.
Just a little.
Just a little annoyed by cocktails. He
Yeah.
did not think it was really in good faith that
Yeah.
cocktails was done. But let's be honest.
Well, but the allegation there is that Jennifer Watson somehow compelled or solicited infringements of Felina's trademark in putting in promoting the anthology, which really is all she did. She's not responsible for organizing it or publishing it or
No,
having any of the stories in it written. Um,
correct.
but on the basis of the facts alleged in the complaint and the petition for the injunction, the judge is looking at her in a very, very negative light. as though
Yeah.
she's some sort of instigator or intellectual property infringer.
That was how she was, made
Painted.
to painted. Yeah,
Yeah,
made
by
to
Felina's
appear.
attorneys. Yep.
Yeah, which was really unfortunate in a variety of ways. And the judge has a quote in the transcript, which I do not appreciate at all as a publicist.
This has gotten under her skin so bad, you
Oh my
guys.
God. The judge, I mean, I have moments where I like the judge and but that makes him a good judge, right?
Mhm. Yeah.
But we'll get into that. We'll get into the transcript. But so where we're at now is that the TRO has been lifted,
Yes.
Cocktails is released, and we have a hearing in a week. So now the question is, notice they have to serve, right? The plaintiff still has to serve the complaint on the
Yes.
defendants.
Yeah, for anybody who's really unfamiliar with the legal system, in civil lawsuits, when somebody sues you, a process server has to deliver a copy of the lawsuit to you, or you are otherwise required to receive some sort of notice that you're being sued so that you can respond. And there are all sorts of deadlines that are associated with that process. And so the obligation to answer a lawsuit doesn't even it doesn't attach, or the clock doesn't start ticking on that until you have been served or have
Right.
received the notice that's required.
And for service of process, you can technically know about the lawsuit, but not
Yes.
have been served. And the clock does not start
Yes.
ticking until you
You
are properly served.
you can have
So,
actual knowledge, and
yes.
as long as the service hasn't been accomplished, because it's a very different thing.
Yeah.
Um in most jurisdictions, and in this one in particular. Yeah, you can evade responding to the lawsuit
Right.
indefinitely. I had the misfortune of practicing as an associate underneath a sole partner who ultimately lost his license for helping people evade service of process, among
Mhm.
other things. Um,
Right. I
so
mean, you shouldn't evade service of process,
no, you should
but
you
you
should
can
not.
you should not. But you can have actual knowledge that something was filed against you,
Uh-huh.
right? But not have
Yeah.
been served properly, and therefore you don't have to respond until you actually have
Right.
been served properly.
Right.
But so there's service is different than notice, as we're
Yes.
saying. Okay.
Yeah.
So there has to be notice of this hearing that's
Mhm.
happening on June 1st go out, right? And
Yep.
so everybody eventually does get notice of the hearing,
Yes.
but good freaking golly, does the attorney for Felina make a big fucking deal about trying to say that Tara Crescent and Jennifer Watson are evading service of
Yes.
process?
Yep.
Sir, it has been like 4 fucking days. Calm
Right?
yourself. Calm
Yeah.
yourself.
Yeah, the way he tried to throw defense counsel and Tara and Jennifer under the bus during the evidentiary hearing
Hmm.
for the issues with notice and service on their parts, like, my guy, it hasn't even been 10 business days.
Right. Like, I just found that completely unprofessional to try to make this big
Yes.
deal about service when
Uh-huh.
it's been they're on a holiday weekend. So
No
we are
less.
now, yeah,
And two parties who are completely outside the jurisdiction of this court, but for the fact that there's a federal question involved in this
right,
litigation, which is why we're in the Southern District of New York, rather than where Jennifer lives, or where Tara lives, or
right,
where, anyone else lives for that matter, right?
correct, yeah,
So you got to get process servers in every location, coordinate, get them the documents they need, and then they have to track these people down,
right.
right? And
So
actually make sure that the paperwork's delivered to them.
yeah, so they filed this on a Friday before a holiday weekend. So I'm
Yeah,
guessing also Friday afternoon. I don't have I don't have exact
I
when
know.
the
Don't
time.
you wish the docket was time stamped?
I wish it was time stamped, but I wouldn't be surprised if it was Friday afternoon. Okay.
At
So
3 o'clock.
yeah, they file this. I doubt it was at 9 a.m. Right.
Yeah.
Because when you're playing fuck games as an attorney, you go for gold. Right.
Fuck, fuck.
Yeah. That's what this is.
No, you're not wrong.
Okay,
Like, you are
this is
100%
part
correct. I don't think I've ever heard you use that turn of phrase. Well, I don't think I've
this
heard anyone call it that before, but it's such a brilliant way to label it. It's
it's
one
what it
big
is.
screw you game. Yeah.
Yeah. And this is really one of the part of the reasons why I hated being an attorney, because this is common practice. This is not like an
Yes.
attorney would be like, you that attorney Cardillo, I believe is the Felina's attorney. He would be
Yes.
looked at his peers and be like, "Oh, you gave it to them on a holiday weekend on a Friday? Like good for you." Like,
Yeah,
you
there's the
know,
practice of law, and then there's the mind fuck that happens between attorneys, right?
yeah,
Like, and the power struggles and this
100%.
this culture of the bar is on the floor, and my professional
Yeah.
responsibility and obligations to you as opposing counsel are just marginally above that bar because I'm trying to zealously represent my client by another bar's standards up here. So there is a lot of this psychological shit that happens in the practice of
Tons.
law, which
Yeah.
makes it completely unbearable for anybody with actual morals or some sort of ethical compass.
Yeah, to do litigation, it is very challenging,
Oh God,
to do
the
litigation.
worst.
Other aspects of the law are not as egregious with this,
Yeah.
but litigating attorneys, oh my god, this is common. This is
Yes.
of
Like,
course he did. Of
right.
course.
I am an
Yeah.
asshole, but I am not the right kind of asshole to be a litigator. And I found
Right.
that out after 7 years of
Same.
practice, right?
Same.
Like,
Yeah,
I,
same.
I am absolutely an asshole, but I am not that kind of an asshole. So
Right. It's
here we
just
are.
and they get enjoyment out of this. They're like, "Oh yeah, right before,
Yes.
holiday weekend, like,
Yeah.
oh, he's going to get the notice on his, phone or
Yeah.
whatever,
And
his
and
email."
and fuck these authors and this publicist and this anthology. Like we're
Mhm.
gonna screw everything up.
Yeah.
And, we're going to show them that we have some sort of leverage or power here using the legal system.
It's psychological warfare is what it is. And there's a lot of that
Sure.
in here that they try to do, and
Oh God,
don't
yeah.
worry, I'll highlight it. But so anyway, they file this Friday, right? And
Uh-huh.
so Monday, the court's closed. So now we have Tuesday, Wednesday, Thursday, Friday, because the June 1st was a Friday, right?
Yes,
Am I
yes.
correct in that?
The hearing is the Friday after the first filing.
Yeah. And so there's a letter filed by the counsel for Terra Crescent.
Mhm.
She's there. I believe is it? No, it is he. He files this letter to the court on May 29th, which is
Mhm.
that Tuesday, right? Tuesday, the
Yeah,
court's now open. First day
right.
of business. And he files a letter to the court and basically says, we represent Tara Crescent, where we're writing jointly on behalf of her and the other named defendants, Kevin and Jennifer, right?
Yeah.
So one letter for all defendants, much appreciated. And basically says, nobody's been served with this complaint. We were notified last Friday afternoon.
There it is.
There it is. Before the complaint and motion were filed,
Uh-huh.
um, you know, plaintiff's counsel attempted to notify the other two defendants prior to their retention of counsel. They're scrambling to get attorneys, right? Because they hear that
Because they get sued on a Friday afternoon before a 3-day holiday weekend.
yes, yes. So the undersigned, who is Tara's attorney, appeared before Judge Ramos on Friday along with
Yeah.
plaintiff's counsel to oppose on the day of the complaint was filed
Yeah.
on May 25th to oppose plaintiff's request for a temporary restraining order. And Judge Ramos denied plaintiff's emergency motion in light of plaintiff's significant delay in seeking judicial recourse. So here's the thing. Felina was coming into the court and saying, this is an emergency,
Right.
right? And they went in for this temporary restraining order, and the defendant, Tara's lawyers, pointed out, like, she's known about this for 7 months.
Yeah.
Like,
Yeah.
there's no
She waited
emergency.
until less than a week before the publication of this anthology to try and stop the publication of this anthology.
Yeah, but she's known about Tara's books the
Mhm.
only one who's named here who has even potential of alleged
Right.
infringement.
Right. Well, because
Um,
she's the first person, I think, to publish anything with cocky in the title after Felina filed her
right.
to register her trademark, right?
I believe so, yeah.
Yeah. Yeah. And that all happened about 8 to 9 months prior to this lawsuit being filed. It was the fall of 2017 when all of that went down, and Tara ends up in the crosshairs of Felina and her attorneys.
And yeah, so Tara's attorneys goes in there and they're like, plaintiff has known about defendant's use of the word cocky in romance
Yeah.
novels titles since at least August of 2017. We are standing in May of 2018. This
Right.
is not a fucking emergency
Yeah.
in legal terms. That's what they were
Yeah.
saying. And the court agreed and said, yeah, no, that's when they lifted the temporary
Yes.
restraining order, and they set the hearing for Friday. Um, and so the defendants are saying, like, we think that Friday's too soon, that this is obviously not an emergency. Like, we don't need to, rush this. There's no
We
chance
still
for,
have an issue with service.
yeah,
Like, there's actual knowledge, but there has not been proper formal legal service of process.
right.
Like, procedural hiccups here, things that have to be addressed according to the, I mean, federal rules of civil procedure at a minimum.
And they're like, we would like some limited discovery. We want to
Yep.
do some stuff before we get to actually coming in for a hearing.
Right.
And so then it becomes a letter war. Okay. Now we're in a letter war
Which,
because
by the way, I have never seen
never
such a
seen this.
shit show of correspondence
No,
between counsel and the court. I mean,
never,
this, like,
never.
at least it was an ex parte, right? Like, which,
Yeah.
for those who don't know, is when someone tries to communicate with the judge privately,
Yeah.
in a way that would maybe prejudice the opposing party, right?
Yeah.
Um,
There are very
but
limited
still,
circumstances when you could privately speak to a judge in an
yes,
ongoing court case.
yes, absolutely. And there are a whole bunch of rules and case law out there about what is and isn't proper, and how that actually can be accomplished without being considered some sort of reversible error or appealable
Yeah.
issue. Um, yeah, I don't think in all of
I
my years
never.
practicing I saw anything like this in terms of the flurry of letters rather than pleadings,
Motions,
no.
right. No,
Right.
there's no pleadings.
Motions and memoranda, sure, right?
Yeah.
Complaints and answers and affirmative defenses, absolutely. But just like on
Letters
firm letterhead correspondence between counsel and the court. And
in
it's like,
a federal case, no
right.
less.
Well, and the judge isn't necessarily responding to these
Right.
correspondences on the docket, but like one attorney sends a letter and then the next attorney sends a letter responding to that letter, and it's all part of the record, and it just was very unusual approach to getting this case resolved.
Truly, truly unusual. It is so odd. I'm glad you had the same takeaway because I saw this and I was
Yes.
like, we're in a letter war? What the
Yeah,
hell? What
literally, I was like,
is
what the fuck are they doing?"
yeah, I was like, why isn't this an emotion? Like a motion to delay
Right?
hearing or whatever. What is happening?
Maybe there's Southern District specific rules about this that we just aren't aware of. That's
That
the
is
only
possible.
explanation I can come up with, is that this is some sort of local rule. And
So
if anybody out there is listening who's ever practiced in the Southern District of New
yeah,
York, you want to enlighten us, feel free. But that's the only thing I can think of,
it was
because
odd.
this is just so not standard in most other places, as far as
Yeah.
I know.
So to explain to some people, there are the civil rules, right? Like there are
Yes.
there are different rules. There's the standard rules that you learn that you're forced to learn in law school. And that you hope you learn, but
Yes,
then,
pro.
yeah, Cipro. But then when you join, you have to be admitted to a federal court. Like you need a sponsor to come with you to federal
Mhm.
court. When you become an attorney, you're a state attorney. You are
Right,
like within your state, you can go and appear in front of state courts. But if you
right.
would like to go and appear in front of a federal court,
You have to be admitted to do that as well
yes,
separately.
that's separate. And so like I
Mhm.
had a sponsor and he like sponsored me and I'm sure you did too. And there was
Yeah.
a whole ceremony and I have a
Yes.
thing. I have like I don't know, it's
You take
somewhere
a
around
completely
here.
separate oath to uphold the Constitution and to uphold the Constitution and to abide by the rules, both local and federal, for this particular federal district court.
Yes. And when you are admitted to that court, you are informed that there are local rules of that
Yes.
court. And you are expected to follow these rules. And they have to do with usually like the way that they do things, right? Like
Yes.
for pleading requirements, you
Hmm.
have to do it in this way and that way. It's
Yeah.
like how they run things.
Yeah.
So what Veronica is saying is it very well could be a very normal practice in the Southern District of New York to file these letters, that's how they
Yeah.
prefer that this information be passed about, but
Yeah.
that is not something that I had seen previously either.
Girl, let's see. I How many federal courts have I been admitted to? Just the Middle District of Florida and the 11th Circuit. Oh no. Northern Indiana Pro Hoc Vice one time.
Ooh, look at
Never.
you.
I know, right?
Yeah.
Um, yeah, I think that's it. Never. Okay, so my sample size is really low, right?
Well,
But
I'm
like
in the
there
Maryland,
there's
one,
enough
and
variety there, right, between the two
yeah,
of us and our experiences that like this
I've not
is
seen it. I've not
yeah,
seen it.
no, not at
So
all.
very interesting. Anyway, so there's a letter then written back from Felina's attorneys,
Yeah.
basically saying that defendants are attempting, there are efforts by the defendants to thwart service.
Mhm.
Um, okay,
Thwart
sir,
service.
sir. He says, despite what I believe to be efforts by the defendants to thwart service, on Sunday, May 27th, 2018, I overnighted Federal Express a complete and accurate copy of the OCS to Kevin Watson and Mr. Schulter's firm on behalf of his client, since they refused to provide me her contact information.
Right.
Because Tara's in Canada, and Tara also, we later find out, and it's presumed, honestly, from anybody who's in the romance industry for 2 seconds, that it's a pseudonym, it's a pen
Yeah,
name.
it's a pen name. Yeah.
And so they're searching for Tara Crescent to serve. They're not going to find Tara Crescent to
I
serve.
love
Okay.
how they went out of their way to geographically survey the area in which they think she lives, and they came up with a street in a
Yeah.
town near Ontario, Canada, and they're like, "This is the only record of Tara Crescent we can find, and it's an actual street in this city in Canada." Like, okay, I,
Okay. But Bro has been, I usually do not, disparage attorneys in this way. At least I try not to.
right,
But Bro has he's earned it with these pleadings. He literally is like saying that they're trying to duck service. It has been 3 days, okay?
literally,
Literally, actually 3 days over a
yeah,
holiday weekend, and he's
yeah,
like saying they're trying to thwart service. You don't get to say that somebody's trying to duck service until like you have made substantial efforts to try to serve them, and then you have like documented proof of them like moving from location to location. Like
yeah,
it takes like a couple months to say that
yeah,
they've evaded service. Like,
yeah,
come on. Come
minimum,
on. Yeah. He also, goes behind and says that, Watson is the force behind cocktails,
the force.
the force behind it, that she played a key role in a juggernaut attack on Felina's trademarks. Um, and that since Felina has been the victim of anti-intellectual property crusade, there has been an onslaught of books published that purposefully infringe on her trademark. I laughed so hard at that line because I forgot about that. I
Yeah.
forgot that people went and changed their book titles.
There was a window of time where everybody was publishing a cocky book. It
Yeah.
was cocky something or something cocky. Like,
And during this whole thing, literally thousands of romance authors went onto Amazon and added, I know some authors added to their actual books that are already in existence, like the word cocky somewhere.
yes.
And just out of protest.
Yeah.
And that made me laugh really hard that it
Yeah.
was
There's
he's
the collective industry wide fuck you to Felina for
right.
overstepping, you know? I mean,
Right.
Maybe her heart was in the right place and her intentions were good. She says that she was acting on business advice from a trusted business acquaintance or friend. And that may very well be true, but what she actually did,
Right. It was bad advice. That's what it
yeah, it
was. It was
was.
bad
It
advice.
was. Or the way
Um,
her attorneys executed it for her maybe was an overreach. I don't know that she necessarily
well,
had the lay of the land in terms of what can and can't be trademarked.
right. This definitely, is he zealously representing his client? Yes. But is this an
Yeah,
overreach? Yes. Also, yes.
happens all
Massively.
the time.
Happens all the time. But it's, he's using the words like, because of the flagrant attempt by Crescent and Watson to avoid service. Sir, it has been
The best
3
part is
days.
they allege that there's an address for Watson. And then her attorneys come back and they're like, "Yeah, she's never lived there. That's not an address ever that has ever been associated with her."
Right.
Like, dude's got his facts wrong and then is complaining that these
Yeah.
people are not, doing their due diligence and just submitting themselves to service due
Yeah.
process. Like, my guy, how long you been practicing? That's a you problem, not a them
Yeah.
problem.
Exactly. Exactly. So, then the defendants actually file a opposition to plaintiff's
Yes.
order to show cause the day before the hearing. So they file that on May 31st.
Yep.
And it basically has all the legal arguments in it. I mean, there's a variety of things. The one thing they say, Kevin shouldn't even be here. Like,
Yeah.
Kevin shouldn't be
Like,
here. He,
this
it,
man
ba-
has done nothing to Felina except for petition the Patent and Trademark Office to dissolve her registered mark.
Right. And so this is just an attempt to, almost retaliation to include him
Yeah.
in this. And also try to bring that case into this court's jurisdiction. And like,
Right.
that don't play. Like, that's
Right.
not appropriate to do. If you want to
Mhm.
fight that case, go over to the US Patent and Trademark Office and fight that case.
Yes.
Right. And then they say, what we've said about Jennifer before, she is she was just the publicist here. She was just promoting and marketing the book.
Mhm.
She did not create the book. She didn't write any of the stories. She had
Yeah.
nothing to do with it, and she was doing it for free.
Yes.
And then for Tara, they say essentially that Felina knew about Tara's books for months. And she actually admitted that she didn't think it was going to be a problem, that there was no issue, like in
Yeah.
messages to Tara. So Tara's like, all right, we're all good. And then she goes and,
Right.
files this
And that
lawsuit. So,
despite the use of the same word in book titles, that there's no confusion, that consumers know exactly, a
yeah,
bunch of other things that are in the legal test for whether or not we have
right.
a cause of action here on the allegations that Felina has made.
Yeah. And the court goes through the tests, at the hearing as well,
Yeah.
for that. But in order to see if there's something that they should go, I'm trying to think if there's anything else in here that specifically I wanted to pull out
To highlight
to
from
highlight.
the memorandum in opposition.
Yeah. I mean, I
Yeah.
highlighted, but the question is, do you care? Um, no, I mean,
Only for the juiciest stuff.
I know. They brought up good points, though. Like no one person should be able to claim a monopoly on such a commonly used word for book
Mhm.
titles in a genre. To do so here would be like an author claiming trademark rights in the word death on a series title for murder series and mysteries and suing
Yep.
anyone who uses that word in their crime stories. It's, yes, that 100% is very true. Um, and, cocky is commonly used in terms of romance novels. I
Mhm.
like that this was actually written in a pleading. Like, I just had to take a step back and be like, this is an illegal pleading. Um, Cocky is commonly used in terms of titles of romance novels, in part because of its double entendre as a sexual innuendo that references part of the male anatomy, and a synonym for being arrogant or a bad boy, both of which are relevant themes in these types of stories.
Yeah. After reading the transcript of the evidentiary hearing and the motion arguments, I will never look at the phrase male prowess the same.
Yeah, very, very true. Um, They did also, they brought up Cockygate as well
Of
in their
course.
opposition, and
Yes.
called it a confluence of events that have turned into hashtag Cockygate.
Someone
And
someone started a fire and now it's out of
yeah,
control.
and they also say that cocktails is essentially a parody.
Yeah.
And I thought that that was a really clever and fun argument for it
Mhm.
because it essentially is.
Parody's
Um,
fair use.
Parody's fair use, and they used a case with Barbie Girl, the song from Aqua.
Okay, he's a shitty human being, but Judge Kaczynski, like that's a nerd thing for me. I
Yeah,
love that fucking case.
it's a
Okay.
great
Oh,
case.
the parties are advised to chill.
Yeah, it's a great case. And
Oh,
they came out and said that, just Barbie Girl's a song about the values Danish
yeah,
musical artist Aqua
Mattel
associated with Barbie
sued
dolls.
Aqua, yeah,
Yeah,
for infringement, and the Ninth Circuit held that it was fair use because it was parody.
it was parody. And
Yeah,
so I thought it was clever that they brought that in here and said,
yeah,
listen, it's parody. It has a large rooster on the cover.
uh huh,
And, they're essentially just the stories themselves occasionally reference chickens and roosters. And like the point was to show how ridiculous this is.
yes,
And anyway, I thought that that was important to highlight as well with cocktails
yeah,
specifically. Um, and then they go through, let's see, yeah, they go through the test and basically knock down every single thing
yeah.
in the
They
test.
they there are certain things that the court has to analyze in its fact-finding mission,
Yeah,
to determine whether or not Felina's complaint can proceed. And, are we going to litigate this and go through summary judgment and maybe have a trial on it eventually? Or are we going to likely dismiss it because there just isn't, there aren't enough
yeah.
merits here, right? And so there's this whole legal analysis. It's like 8 steps, right? Or 8
Oh yeah,
factors.
and the
It's
Rogers test, I
pretty,
believe.
yeah, yeah, it's layered. It's like an onion. You peel one layer back, then you got to look at another one. Just
Yep,
go all the way through it. And they address all of those in their opposition memorandum, and then that is something that they discuss in depth during the hearing.
yeah. I did like, so one of the steps is to determine whether limiting the use is in the public interest or not, right?
Yeah,
Like whether the trademark preliminary injunction, excuse me, limiting the use of the trademark would be in the public interest. And I
right.
thought it was really funny in the opposition. The last line, this is how they end their opposition, right? No public interest would be served by delaying adjudication of Kevin's cancellation proceeding on the merits. To the contrary, considering the fervor that has propelled cocktails to number 25 on the USA Today best-selling books list, it appears that there is a strong public interest in permitting that cancellation proceeding to move forward so that fundamental issues of registrability underlying Cockygate can be meaningfully resolved. They're basically saying that, like, if you want to look at public interest, the public has spoken. It's at 25. The public
Yeah,
is saying we don't support this. So
yeah,
that's clearly in our favor. And I thought that was a nice way to end that.
absolutely.
Then we have the hearing,
Oh, the good old days when you could put together an indie anthology and hit the list.
right? I know. Let's have a moment of silence for that.
Pour one out for the original USA Today bestseller list.
Yeah. Yeah. Oh my God. Okay. So now we're at the hearing, right?
Yes,
And
yes.
literally, I think we're in 2 pages in the hearing. I mean, it's a little further than that, but um,
We're already having a pissing match about service again.
yeah. But Kevin gets removed in
Yeah,
like
like
2 seconds.
luckiest man involved in this case right now
I
is
know.
Kevin.
But the court is just basically like, what the fuck are you doing? Like, I don't have jurisdiction on that. Like,
Yeah.
you want to go fight
This is
that?
not an issue I can hear. This is not
Yeah.
a thing I can decide. I do not have any sort of jurisdiction over this man or his petition to remove the registration, to cancel the registration. Like, get
Yeah.
him out of here.
He
And
literally
so they
said,
do.
The court says, "I'm not going to say proceedings before the evidence. You go ahead. Whoever wants to go and do whatever you want to go do there. It's not my jurisdiction. You go ahead. I'm not staying." And the attorney for Felina says, "Certainly, Your Honor." And the court says, "How could you bring in the person who filed it?" And Felina's attorney says, "We believe because he filed a petition without standing. In other words, he claims in his petition." And the court says, "That's the defense you make there. It is not going to be a reason to bring in somebody else."
Yeah. Yeah.
And then they
Here's
say,
a
"Oh,
defense we could file in the USPTO courts, right? But
right.
like, we're just gonna ask you, random federal district court judge, to go ahead and deal with this for us, even though
Yeah."
completely outside of your constitutional purview.
So, like on page 6 of the transcript, it's
Yeah.
okay, Your Honor, we'll withdraw that to Mr. Nupper. And the court says he's out of the case. Like Mr. Nupper's out of the case. So, page 6, he's out of the case. So, his attorneys that have appeared and actually who helped prepare some of this stuff and were planning to argue
Yeah.
now can't speak. They're now out of the case. And that actually
Yeah,
becomes
their
a,
client's done. They have like
yeah,
they literally have no more dogs in the fight, so to speak.
right. But it actually became a little bit of a problem, I think, because he did prepare a lot of this. And then one of the other attorneys had to step up
Uh-huh.
and do the argument, and she wasn't
Mhm.
as prepared. Not that she did a bad job. I thought she did a fine job, but you could tell like she was
This is
not.
Tara's attorney, right?
Yeah. She was not
Yeah.
as prepared or necessarily was the one that was planning to speak on behalf of
Right.
everybody.
Right.
Um, but yeah, the judge basically is like, what are you doing about this service thing? The judge is like, you know, are you going to, the attorneys are here. Like basically they get through the whole like service stuff. And then
Yeah.
the judge is like, well, you're here. Can you accept a service on behalf of your client?
Right.
And most of them are, Jen's attorney was like, yeah, I can. And Tara's attorney, I understand why they were hesitant because Tara's in Canada and there's potentially a jurisdiction issue there of her being
Yes.
even. So if the attorneys
Right.
accept service, they're essentially saying that like we're good to go, like we're sort of waiving that,
Yeah.
right?
Yeah.
So there was a potential. It wasn't them being assholes. It was them trying to see
No,
if.
she eventually capitulates to it and agrees to accept
Yeah,
service on Tara's behalf. But I think the reluctance to do so, to your point, is about the requirement to get things procedurally correct, right? So
right,
when you're thinking about how you're going to prosecute or defend any sort of litigation, at least on the civil side, every single step is an opportunity for you to preserve some sort of appealable issue. In
right,
case you lose, you can go to the next court and say, hey, we shouldn't have lost because of all of these things that happened in the lower court. And it starts with service of process. And with an international defendant, that's
yeah.
a complication that, maybe as a fuck you to Felina and her attorneys, you want to force them to go out of their way to
Yeah,
figure out how to serve this person who is across an international border,
because there
you
are
know?
extra steps. I've had to serve somebody internationally before. It is not super easy.
I
You
believe that. That's an
you
experience I never had, but I'm sure it's very complicated.
It is very complicated. You have to contact the appropriate in law enforcement,
Mhm.
people over there. You have to make sure that you have the right people. Everything has to be certified. Like
Oh
it is
god, so
not
we're getting like the RCMP involved now. We got the guys in their red suits with their,
depending upon where you are, right? Like
yeah,
so different
right.
countries may have different requirements.
Yeah.
They have to sign off on different things. It's a whole thing. It
Yeah.
is so I can understand why her attorneys are like, I don't really want to make it that easy for you. You
Right.
have not made it
I'm not
because remember,
obligated to do that. I'm
yeah,
not obligated. The rules say you have to do this, and since
yeah,
you're filing lawsuits on a Friday afternoon before a holiday
that's my
weekend,
point, right.
maybe we just say fuck you right back and we force you to find a way to execute service in Canada.
Yeah,
Like, get bent.
right. So, like, you're not doing us any favors. Why am I gonna do you a favor and just accept
Exactly.
service? So,
Exactly.
it was not so much like I give the same energy as I get, and so that's
Girl, same.
yeah. So that's the energy that they were having there. They were
Yeah.
like they were matching energy and they were just like, yeah, we're not going to
Mhm.
make this simple. But
Right.
so we get through all that and the court's like, "Well, you're here. All right, you have notice for this hearing. Like let's start talking about this." So Jennifer's attorney is like, she has nothing to do with this. Because Kevin, you have to remember, 2 seconds ago, Kevin is knocked out of this case.
Yeah.
Jen's attorney speaks up and is like, hey, I would also like for my client to not be here because my
Right.
client shouldn't have to be here. Court
My,
does not
my
agree.
client is a publicist and a publicist only and is not responsible for any of the actual infringement if there has in fact been some sort of infringement.
Right. What drove me batty was this court said, as a publicist, she has a responsibility not to infringe. If this is a protectable mark, she infringed on it. Sir, no.
Yeah.
No. That is not accurate. I respectfully disagree.
I dissent.
Um what?
I said I dissent.
Oh yeah, 100%.
Yeah.
I also don't think that if that would have gotten to that far, I do not think that would have held up as a statement of
Yeah.
new law.
Yeah.
No,
In
because
some situation where we end up with actual case law in the Federal Register over this particular conflict, I don't think that that stands.
no, there's no way, because as a publicist, you don't have knowledge of where your clients are getting certain things from. You
Hmm.
are literally engaged to perform a specific
Hmm.
task, which is, outreach or creating
Yeah.
graphics or,
Yeah.
whatever. You're helping with the marketing of the book. You have absolutely no
Yeah. You are
control over the creation of
connecting the publishers of the book,
it.
in this case, a group of authors who've gotten together to do it with media and
Yeah,
influencers. And you are coordinating press releases and other promotional postings online or advertising. And in no way, shape, or form does any of that relate back to the generation of the content itself or
right,
how it might or might not relate to someone else's intellectual property protections.
right. I just thought that was absolutely wild of him to make that
Yeah.
statement. And yeah, I did not think it would hold up. That is also, though, why we have a clause in our contracts that basically indemnifies us for any
Yeah.
sort of thing like that.
Yeah.
And if people want to
I,
know why does that exist, because a judge said that in a real
yeah.
thing. And we saw that
Yeah.
and said, oh, hell no, we need to protect ourselves just in case.
Absolutely. And
Um,
it goes deeper than that too. I mean, we've had a handful of experiences over the years where authors have misrepresented the nature of their work or
yeah,
other things associated to their businesses. Um, we want nothing to do with being on the hook for that.
yeah. We only know what you tell us.
Yeah.
And if you are misrepresenting something as an
Yeah.
author, how are we liable for that? So we needed to ensure that we would not be.
Yes.
But yeah, wild, wild. So that's that. That was my annoyance. One of my annoyances.
One of many that
One
come
of
out of
many.
this hearing,
Yeah.
unfortunately.
I mean, you have to remember the court is not in Romancelandia. The judge is not reading.
Maybe he should be.
Maybe he should be. I agree. But unfortunately, and I've seen a variety of these cases, oftentimes the court is not well versed in the community, in publishing,
Yes, especially
um,
self-publishing, indie
especially self
publishing.
publishing. They're used to, when they have publishing issues, it's usually between publishers, larger
Mhm.
publishers, and they when they dabble in this stuff, they sometimes can't see the forest from the trees,
Yeah.
and it can get very frustrating. Anyway, next thing up, they eventually decide that Tara's name will be submitted under seal because,
Yes. Yeah,
you know,
they're going to disclose her true identity and keep it out of the public record of the lawsuit.
yeah. So then they start talking about the trademark itself, and the court asks the question that is on everyone's mind: how can you trademark the word cocky? Sir, we are wondering the same.
Oh, inducing my male prowess vomit response.
Oh my God, yeah. So, he goes into the whole, it identifies the book, it's a source
Mhm.
identifier, which is a buzzword that you need to say, like that's the whole thing.
Yeah.
And they go back and forth in regard to this. And then, they're talking about if I was
Remember,
buying a
there's this
book.
whole discussion between about like Cocker brothers, Cocker family versus the use of the word cocky, right?
Yeah.
Like,
Yeah.
and distinguishing the very knife edge thin line on which the argument between the parties really exists, right?
Right. Yeah.
Yeah.
Well, and they talk about, how cocky. So, for example, one of the book titles is "Cocky Mother's Day," and
Yes.
how Mother's Day is obvious. I know Mother's Day is obviously a descriptor of the content of the books. It's about Mother's
Right.
Day, and
Right.
cocky is arguably they're also a descriptive of the book about the male prowess of whatever. And the court is really confused as to how you can have a cocky Mother's Day,
Yes.
um, and so
The
thus
court does not understand romance readers.
correct, and that's very obvious. But um, yeah. So they're talking about the differences between an adjective and a title versus a
Right.
trademark source identifier. Like
Yeah.
if you were to say the Twilight series, for example. But this is why titles cannot be trademarked because
Yeah.
titles are essentially adjectives or descriptive of the contents of the books. They are not
Mhm.
source identifiers of a specific thing.
Right.
They also talk about how on the cover, the main identifier is the author's name, and how that is a big,
Mhm.
thing. The
Yeah.
court then goes and he said he's looking at the Polaroid factors, which is what he's looking at
Mhm.
during this hearing. And Polaroid is the name of a case. And he says, it seems to me at this stage in the litigation, it's a weak mark at best.
Yeah.
So, we're looking up. We're looking up. We still have
Yes.
another 20 pages worth of hearing, but things are looking up.
That's because lawyers
Um,
love to talk,
right.
as is evidenced
Um,
by this podcast.
true. I did love that they handed him up the cocktails book.
Oh my god, yes.
Like handed him up a copy of the
Mhm.
paperback of cocktails,
Yeah.
and the judge says, I am not going to keep the book. And the attorney says that's quite all right, and the court says I'll consider the title. Do you have a color picture? And then he starts talking about this is a deliberate parody, et cetera, et cetera. Oh, one funny thing. Don't make jokes, by the way, to a federal court judge. They don't land. No one's going to laugh.
You like have to really know the judge. Like
Yeah.
like you're members of the same bench and bar social organization, or you've appeared before this judge like a lot.
Yeah.
Um yeah.
Because the
There's a
attorney,
reason there's a reason the idiom is sober as a judge, right?
yeah,
Like
the attorney for Tara,
yeah,
basically, they were talking about the titles. Cocky Doctor was one of
right.
them, and she makes
Her cocky firefighters.
yeah, and she makes this. They're literally
Uh-huh.
describing what the is on the cover of these
Yeah.
books. And her attorney basically says, like, well, he doesn't look like my doctor. And I can only imagine the crickets that were in the courtroom.
Well, and she's the only female in the
Yeah,
speaking in this hearing, right? The other attorneys are men, and the judge is a man.
yeah. And it did not land. The joke did not land. They just moved on to something else. It was it was cringy as
Womp
I read
womp.
that. It really was. Um, I was the other thing is so that one of the issues in the test is
Uh-huh.
confusion. Okay.
Yes. Yeah.
And
How likely are consumers to be confused by the alleged infringing product?
yeah. So Felina had put forth these three like screenshots of these like three alleged instances of
Mhm.
confusion, supposed confusion between her books and some other book.
Yeah.
And the only one that had a title in it was Cocky Chef, right? That someone was confusing Cocky Chef with that Felina had written. And then Tara's attorneys are like, well, Cocky Chefs isn't my client. My client has never written Cocky Chef. So, like, none of these alleged instances of confusion are even
Yes.
related to my client's books.
Right.
And, it's not even clear what these people were confused about. And so the court's like, if it relates to someone else that has published a book with the title Cocky in it, and um, their attorneys are like, well, that party's not here. And the
Right.
court's like,
Like,
well, Felina's attorney, like, how do we know this refers to the defendant's books? And the attorney has to admit, Your Honor, I can't represent to the court that we can make the connection to these three defendants. So basically has to admit that there might be
I'm done. I never show up in that judge's courtroom again. I'm sorry.
no,
Like you could not.
no,
There is no amount of fringe benefits, salary or partnership, equity, nothing that could make me set foot in that man's courtroom again after having to
no.
say that out loud as part of the argument on the record. Oh my god.
That yeah, people are confused, but not with these defendants because oh my god, I was so mortified. I
I
was like,
know. The
oh
the cringe, right? Like ooh. Mm.
yeah.
No. No.
Yeah. Yeah. So the
No.
court's like, they're not in the case. And Felina's attorney says they are not in the case, Your Honor. That's correct. So the court says, I
Why not
can't.
Felina's attorney? Why not?
Why not?
You're literally using them as evidence in support of your claim against these other people. So why aren't these people in the lawsuit too?
Right. Um, and so the court says, I can't credit this as indicating actual confusion. The other instance that
Yep.
is mentioned is a reference on a web page or a criticism. It's unreliable. No one knows who placed it. No one knows who sent
Yep.
it, nor the purpose. Um,
Anonymous hearsay more than anything else.
yeah. So then they go into sort of the title and the layout, and they're trying to say that Tara was acting in bad faith because of
Yeah.
how she presented the title on
Block
her
font.
book. Yeah. And what's really annoying is that, and the Tara's attorneys try to bring this up, and they're like, that's literally just how romance books look.
Yeah.
Like that, this is just how it
Just
is.
go to Amazon Kindle and just take a
Yeah.
survey of every romance novel in the top like 500.
But the court doesn't really understand that.
Yeah.
They don't really get that. So that was frustrating. And but the court does find that that the issue can't be resolved on a preliminary injunction, that there needs to be more facts, that there needs to be more
Yes.
information.
There needs to be discovery, there needs to be an
Yeah.
answer to the complaint, like, the Felina is not entitled to stop anybody from doing anything. If actually, what I really appreciated about the analysis by the court was that, if anything, actually granting the injunction would hurt Tara
Right, because she would be forced to
in a
change
way that
everything. Yeah.
right, in a way that Tara could not be made whole for after the fact. Whereas the harm alleged to be happening to Felina can actually be compensated appropriately through damages
Right.
through an actual mathematical calculation at some point in the litigation process. And so the court decides correctly, in my opinion,
I agree.
that it's best not to harm Tara in a way that can't be repaired
Right.
and to risk harming Felina in a way that can be repaired by not granting the injunction. So,
No, it was the
yeah,
right move. It was the right
I
move
think
on
so
that.
too. Yeah.
I did think other funny quotes from this hearing, and then we'll move on because honestly, we could. There's moments. They're talking about the quality is one of the factors. Excuse
Yes.
me, and the attorney for Tara says, "I think this is a neutral factor." Oh, sorry. Before that, uh, the court says seventh is the seventh factor that we're looking at is the quality of defendant's product as compared to plaintiffs. They're pretty much the same, aren't they? And Felina's attorney says, Your Honor, I would say that my client has 600,000 books sold as of today's date, or approximately 600,000. And the court says that doesn't prove quality.
That paired with the other thing the court said about romance books in general is like, it is just so
I,
stereotypical, like
right. I was just like, what the fuck,
snooty old
bro?
dude.
Yeah. He said that, yeah, the court then says that the readers here is very specific to the genre of books, which I would call cheap romance novels.
Yeah.
And so know what is going on and are not fooled particularly. So like he calls them intelligent, but also insults them in the same sentence. It was,
Well, yeah. So, okay, but like as a matter of actual fact,
yeah,
Felina was charging 2.99 an ebook at this point in time, right? It's 2017,
right.
2018, and that's kind of what the market commanded at that time. That was a very conventional price point.
Yeah.
Um, I think it's a fucking steal, if I'm being perfectly honest. Even then it was a steal. But 600,000 copies at 2.99 minus a 30% uh royalty split with Amazon, assuming
Yeah.
we're exclusive. You're talking about what, like over a million still.
Yeah. Still good money to be had.
Yeah.
But so, and so it's very possible that the court was looking at it from a price point wise, but it
Mhm.
just coupled with other thing. I don't know. I didn't get his tone
No.
from the
It it
transcript.
it it harkens back to the days when, and this still happens now as well.
Yeah,
Because it's something that women enjoy, society has less use or tolerance for
correct.
it and is all too happy to thumb the nose or look down on because it's a woman's interest kind of thing.
Yeah,
So,
100%.
cheap romance novels.
Yeah. So the hearing is done. The temporary restraining order is no more. Now we are just
Yes.
in the regular case. So
Yeah.
now the question is, are they going the well, both attorneys who are still in it say we're going to be filing a motion to dismiss, which you
Mm.
do prior to an answer instead
Yes.
of an answer.
Yes.
So
Yeah, don't make that mistake. Answer if you answer before moving to dismiss, you're done trying to get rid of the
yeah,
case.
you're donezo. You're going to have to file a motion for summary judgment, which is as a
Yep,
different standard. You don't want to do that.
totally.
So you have to file a motion to dismiss, and they both say that they're going to be doing that instead of answering. So the court sets a date in which they have to do that by.
Yes.
They
And
do
they also
not.
set deadlines for the discovery process and talk about
Yeah,
that being an expedited thing rather than taking the usual amount of time.
right.
Um, yeah, we're in the procedural weeds at this point, right?
Correct. But instead of filing a motion to dismiss or an answer, the
We
court
get letter practice again.
we go back to letter wars. Yeah. Um, we're now in July, so the time
Yes.
frame has
Yes.
passed for filing a motion to
Yeah,
dismiss.
we have the hearing the first day of June, and the order denying the injunction is docketed like the fifth day of June, and then we get into the weeds on this the
Yeah.
letter exchange.
Well, so
Um,
they would have had to file a motion to dismiss on June 22nd per the court's
yes,
order, right?
yes, that's right.
So there was a letter to the court on June 22nd on that day saying that a settlement had been reached and they were
Yes,
working out the deal, right?
yeah,
Which basically, tells the court this is why you're not getting motions to dismiss. And
right,
should settlement fall apart, likely the court would have allowed for motions to dismiss to
absolutely.
be filed. But
Although, uh, again, maybe procedural discrepancies from one district to the next. I'm still unclear on why one would not go ahead and file the motion to dismiss and then just continue with the settlement proceedings and then
100%.
file a notice of voluntary dismissal once the settlement has been reduced to writing and everyone's bound to the terms. Like,
Usually that's what happens. So that's why I
that's
was a
what
little
I was thinking.
surprised here that that did not happen.
Well,
Because you want to,
apparently the Southern District is Narnia, and you can just, instead of doing motion practice, write letters to the court all day and litigate your case on letterhead.
yeah, evidently so. So Felina's attorney on July 12th writes a letter to the
Mhm.
court and says that it appeared that a settlement had been reached. While that's still the case, finalizing a stipulation of settlement seems not to be possible. So he's now asking that the case be restored so that
Yes.
we can proceed.
We got so close, Judge, but we just couldn't get it done. Can we reopen
Yeah.
the case?
So then same day, another letter. This time from the firm representing Tara Crescent and Jennifer Watson. So now they've now consolidated attorneys. There's been a little shuffle.
Yes.
Um, so the original settlement contained 5 essential terms, right? It was
Yeah.
outlined in an email exchange. The defendants allege that Felina expressly accept these terms and authorized the defendants to advise the court of the settlement in principle rather than have the defendants file counterclaims and a motion to dismiss. The next day, and for an unknown number of days thereafter, plaintiff breached one of the terms before plaintiff's counsel left the country for a 1 week vacation. Upon plaintiff's counsel's return, defendants sought to resolve the breach as well as finalize settlement. Plaintiffs have further resisted all reasonable efforts to finalize settlement and provide relief against further breaches. Defendants respectfully request judicial intervention to, among other things, enforce the terms of the settlement. And they
This
go
is what we
on.
call poor client control on
Yes.
Felina's attorney's part, right? Like,
Yeah.
uh, I assume, and I could, of course, I'm taking a big risk by doing that, right?
Mm-hmm.
And I could wind up showing my whole ass here, but I assume no one explained to her that what she did the day after they reached the settlement agreement would be a violation of the settlement agreement, because why else
Right.
would she have done it?
You would think. I don't know. So, well, then defense counsel, they continue on and they say, well, we'll talk about what she did, but defense
Yes.
counsel says that they've been unable to meet and confer with Tara's attorneys because, despite his filing with the court that day he told defense counsel that he was upstate with limited phone coverage, and so that while he was happy to settle along original terms, um, he,
Does
he
not have the technological access that's
right,
required to actually finalize it. So it it's like it's what I imagine having more than one child is like when they're arguing about something.
yeah.
Like, honestly,
This is really like, mommy,
he
this is,
picked me,
he
she
picked
hit
me.
me.
Yeah,
Yeah, like
yeah.
it's really petulance is what it is.
So Felina's attorney writes back, same day,
Yep.
another letter, basically saying there are numerous inaccuracies and omissions. Most importantly, defense counsel made it very clear that plaintiffs agreed to undiscussed and inequitable terms. For example, gag orders running solely to the benefits of defendants, as well as a non disparagement, and gag order running to the benefit of the Cocktails Collective, a non party, and that no settlement would be attainable. His exact words were, the remaining issue is still a deal breaker. So basically, if she didn't agree to that it would
Mhm.
be a deal breaker. Um, and that he was adamant if settlement under his terms couldn't be reached, he would be filing a very aggressive motion to dismiss, and other third parties would seek to implead. Um, obviously. And then he says that to address his other points, plaintiffs haven't breached any of the theoretical settlement terms. Um, then he says that while I was away in Central Asia on an urgent family matter, not a vacation, I did inform opposing counsel that I could be reached by email, but my ability to make calls would be limited. Like, who gives a shit? Like, this is literally mommy and daddy shit, right?
Uh-huh.
Um, and he also says,
This is asking a judge to make decisions about the the lack of standard level of professionalism here between
yeah,
these attorneys. Like,
this,
this is shit that does not have any sort of bearing on the outcome of the case. It's like, let me just make you look as bad as I can to the judge. Oh,
yeah.
okay, thanks for throwing me under the bus. Now I'm going to throw you under the bus. And it's just a nonstop finger pointing.
Yeah, it's going back and forth, like, oh, we've been in frequent and meaningful and productive and, dare I say, friendly settlement negotiations since the first court hearing. Oh, come on, bro. Come on.
Right?
Anyway, so and then he says that I am in the mountains, a geographical location I prefer over the city,
I loved that.
with limited, if any, cellular service, and I do not have a house phone. So that's why I can't talk on the
Yeah.
phone.
Yeah.
Okay. So then there's another letter.
Still got a paralegal in the city filing all this paperwork for him, though.
Yeah, yeah. Email works just fine. So
Yep.
there's another letter from the defendants this time, when they basically blast him for putting their settlement negotiations in
The
writing,
record.
in
Yeah.
the record.
Yeah.
And
That's usually a big no-no.
yeah, the fifth and final term of the settlement agreement, because this is the only time we're ever going to find out what's in the settlement agreement, right? Like, because That's
I mean,
usually not, well, you would think. That's usually not something that you ever see though in court cases. You
yes.
just see that it's
Yes.
settled. You
Almost
don't know
always
what's,
they're confidential. Almost
yeah.
always.
So the fact that we actually find out what's in the settlement agreement here is like interesting.
Yes.
So the term that's at issue here is that the parties will execute a written agreement that, in addition to the usual boilerplate, provides for general releases and non-disparagement provisions for Felina, Tara, Kevin, and Jennifer.
Mhm.
That's standard. I don't know what the big deal is about this. The issue, though, that defendants take, and I'm like, why are they so mad?
There's a
Because
really good reason,
there's
actually.
actually a really good reason. Because the day after that settlement took place, like that the initial agreement was made,
Yes.
that was on a Friday. On
Bad things
Saturday,
happen on Fridays.
on Saturday, she gives an interview to the Daily Mail,
Uh-huh.
and talks about the entire case.
Mhm.
And she
About how
actually,
Tara and Jen and the Cocky Collective and Kevin were all out to get her.
yeah, um it was, she said it was a deliberate attack against her, so
Yes.
like, and done in malice.
That sounds like disparagement to me. I don't
I
know about
mean,
you.
I don't know
Sounds
about
like
you.
disparagement to me.
She then releases in the article more information about what are the terms of the settlement agreement. So we know that this happened after the settlement agreement was reached, because she tells us what was in there, which was that neither side will pay either any money,
Oh.
and that Hopkins will give up her trademark in a gesture of good faith, and Tara Crescent will change her book covers to an all block font.
Client control is like so
Unbelievable.
important when you litigate. I
I
it
cannot express it enough. Um, so then the then Felina's attorney is super mad that they put issue like some of this stuff in writing, and asked for it to be stricken from the record. By the way, it wasn't.
it
So
doesn't matter anyway.
yeah. So the court then on, I don't know what date this was, 7/17. So this is like
Yes.
5 days later. The
Yes.
court it doesn't even like write an order. He writes, if you can see, if you're watching on YouTube, you can see it up here. This is the court's order right here. If you
Handwritten
can,
note on the
handwritten note
printout. Yeah.
of one of the letterheads. And it says, I'm going to work on this. By July 27th, 2018, defendant shall something that a binding and enforceable contract was made. Plaintiff shall have until August 3rd, 2018 to oppose. So I guess shall file, shall plead, shall. I'm unclear what that scribble is. I'm usually really good with
This is
attorney
why we
scribble, but
usually have an actual proper typed up order of some
yeah,
kind. Like the casualness with which these papers are filed on this
it's
docket
so
is
crazy.
just I mean, my
It's
mind is blown.
yeah, it's wild. So then on
Like you
July
can't even read
19th,
the whole order because it's handwritten.
yeah,
Like
I know.
1918, not 2018. Like, come on now.
It's crazy. So there's a couple more things that they weren't really relevant. And
Yeah.
then on July 23rd, the final piece of this case, um, Felina's attorney writes and says, I'm happy to inform the court that the parties have executed a settlement agreement. As such, I withdraw my motion to dismiss without prejudice and now request dismissal with prejudice. Defendants do not oppose this motion, and the court grants that. In another little handwritten thing down here.
Wild.
Wild. So then what happened was, per the terms of the agreement that we know now because they told us,
They were fully disclosed by someone to the media.
yeah, Felina withdrew her trademarks.
Yes.
Tara changed the cover of her books,
Just the
and
font, though, right?
just the font. Yeah, I think it was just the font. And that was all she wrote. And we didn't hear from Felina, kept publishing books, and she
Yes.
is under Felina Hopkins on Amazon. You can go and
Yes.
download her books. You can see them.
Has published in the Cocker Brothers series as recently as last month, actually.
Yes.
So
Um,
those books are
sh-
still alive and well, and she's still writing them.
she did appear back in the news
Oh yeah,
in 2023, in early 2023.
that's right.
Yeah, she had two incidents in which she had, it looks like, a mental health crisis.
Probably. Yeah.
And I think one was January 27th. Oh, yeah, both cases occurred the same day, January 27th. The first incident happened at Yellowstone Park at 9:52 a.m. when park dispatchers received a call that Hopkins' car was stuck in the snow in a closed area.
Hmm.
And officers went to cite her for driving in an area that was meant only for over snow vehicles, such as like snowmobiles and
Yeah.
sleds and stuff. Um, so the park ranger, she goes stuck. So the park rangers towed her vehicle behind a snow groomer, which they allege was a significant effort on the Park Service's part. Which, let's be honest, that's true. I mean, normally you would have to call a tow truck and stuff. So
Yeah.
the fact the park rangers did that, was kind. And then the second case occurred 90 minutes later in Grand Teton National Park when rangers saw her parked in a road at Jackson Lake Junction and contacted her to move her car. She fled for 24 miles, reaching speeds of 90 miles per hour as rangers pursued. She led them on a high speed chase, and they ultimately blocked off the highway and deployed spike strips to deflate her tires north of Moose. Um, Officers said on the scene that they found no evidence of substance abuse or mental illness. Um, you know, I, who knows? And so,
I mean,
um,
some people hide their substance abuse and or their mental illness very well.
right, exactly. Hopkins said that she thought that the road closed sign between Grand Teton and Yellowstone referred to only an evening closure,
Yeah.
and she was unprepared for the snowstorm. She's from California, and she wasn't used to it, and all of that. Um,
What's she doing in the Rockies in January then?
I it was unclear why she was there. Um,
Is like that
she was
that's as
praying.
big that's as big as the mountains get. Like the Grand Tetons, they're like that's the American Rocky Mountains, like
So she was,
California girl.
yeah, she was praying on her hands and knees outside of her car when she was found, and like when she was
Mhm.
approached by the ranger.
Okay.
So I don't know. I don't
In
know.
some kind of crisis, personal or otherwise, mental health, some
Correct.
sort of issue, right? Like she's having a very bad day.
Very bad day. She spent 4 days in jail. I mean, because they were not pleased with her,
Well, I
you
mean, she
know,
took him on a high-speed
she took him
chase.
on a high speed chase. Um, and her sister said that she was having some mental breakdowns, right?
Okay.
And so that's what it looks like. That's what was happening.
Yeah.
Then she got out of jail from that incident and
Mhm.
then went missing for 2 weeks.
See, this is what I remember. I remember there being a
Yeah.
call on social media about not like her sister being just absolutely in a panic because they couldn't find her. They hadn't heard from her. Her phone
Yeah.
was either off or she wasn't answering it or something. Like they just,
They couldn't find her.
right.
And I do want to say, to the credit of Romance Landia, people did not make jokes. People took this very seriously. People
Yes.
wished for her safe return. People
Yes.
were not mean and malicious. They were actually like, "Have you seen Felina?"
Right.
Or like, "Do you
Right.
know how to
Like,
get in contact with
yeah.
her?" Like,
Do you
it was
guys remember Felina? Like, if you haven't
right.
been reading her all these years, I think most of us recall the Cockygate thing. Well, she's in trouble. We need to come together and find her.
Yeah.
Like,
It was actually very heartwarming to see,
yeah.
and a reason why this community is not atrocious. They hold people accountable for their actions, but at the same time, they don't wish ill will, right?
Yeah,
Like,
super supportive, lift each other
yeah,
up, come together. I mean, for all kinds of things.
yeah, and that was my recollection of that time.
Yeah.
She was then found. They found her in Hawaii. So,
A big change from Wyoming and Montana.
Yeah, she left her vehicle and her dog behind. So that's why like people were really concerned. And they
She
could
left the
not
dog
She
behind?
left her dog behind. Um yeah.
That's heartbreaking.
So her family did go, her family did
Yeah.
take care of the dog and all of that. But
Right, but still, like,
I
I
know.
mean, what it doesn't matter. We're not here to speculate on what somebody's going through, but like, gosh, you
Yeah.
feel for somebody who needs to just like whatever
Leave.
that was, right?
Right.
Wow.
So she was located in Hawaii after they were able to use cell phone tracking, apparently, eventually. I think she had it off for a while and then
Yeah.
she probably turned it back on. They were able to ping it. So, excuse me, in December of 2023, she pled no contest to three misdemeanor charges of eluding a police officer, unsafe operation of a motor vehicle, and having a
Yeah.
vehicle where only over snow vehicles are permitted. She was fined $2,340 in restitution and was to be put on unsupervised probation until those fines are paid. So, all in all, not a bad,
That's
that's
a
a
very mild slap on the
very
wrist
mild.
for everything that went down.
Yeah.
Yeah.
I have to think that the court realized that there were other factors
She
in
was going through
play.
something. Yeah.
Yeah. Because that was,
Atypical behavior on her part. It's not like she had a
yeah,
long-standing history of being on the law's radar, so to
right.
speak.
And it appears that she is still publishing, as Veronica said.
Yep.
So she's
Yep.
publishing books as recently as August of last month.
Yep.
And they have great reviews.
Yep.
She has fallen. I don't want to say like she's not as engaged in Romance Landia anymore. I
Yeah,
would say,
maybe has taken a step back in terms of
yeah,
being front and center with other top brands and
yeah.
authors. Yeah.
I think she got some bad business advice and she ran with it because she
Yeah.
thought that she was doing something in
Yep.
this community and that she was selling 600,000 books or had sold 600,000 books. She felt that she was rising to be a bigger named author, right?
Yep.
And she thought that she was going to protect herself like others do, got some bad advice, and for whatever reason, instead of realizing that, oh, maybe this isn't the best move and getting different advice,
Yeah.
um, that she doubled down and tried to take it as far as she could and alienated a lot of people along the way.
Yeah.
Um, and it's sad. It's sad. I mean, and that's the thing. You got to be careful who you take advice from, and don't be
For
afraid to
sure.
listen to the other side and
Get
other
a second
opinions.
opinion.
Yeah. And if literally the entire community is rising up against you, maybe maybe question if you are in the right.
Like for real.
Like for real. And like even if you legally are in the right, which she wasn't, but even if by chance she
Mhm.
was, is it in your best interest to do something that's so alienating within the community that doesn't benefit the community as a whole when you're trying to be
Yeah, for sure.
this person? But that is the story of Cockygate
What a
and all
story it
its
is, too.
I know. And we did this in total between the two episodes in 2 hours, right? That
Not
apparently
bad.
seems to be our time
Not
frame for
bad.
discussing cases. Not bad at all, because we lived this over,
Oh, Lord.
several months
Yeah.
time frame, and it was a
It was a
thing.
ride in real time, but it's very interesting to reminisce and revisit.
It is, and it brings up really interesting issues of trademark. And you can start to see how, like in the Pippa case, there was a very clear,
Yes,
trademark issue there. They were
absolutely.
suing the correct defendant, number one,
Mhm.
who had allegedly infringed upon Pippa Grant's mark. Whereas
Yep,
here, they were suing, three different people, only one of which had actually potentially even maybe alleged or infringed, and then couldn't provide the exact proof of where the infringement even occurred. So it was, or where the confusion occurred, or any of that. So you just really need to have these cases tighten up. And when you start to stack them next to each other, it's, you start to
You
see,
can see the disparity between the two. I
right,
mean, the
why one wins, why one doesn't.
right, right,
Yeah,
and how much tighter and, uh, how the facts supported Pippa's case way better than the,
yeah,
uh, sloppy, I guess, allegations here in Felina's case. Just a
absolutely.
night and day difference for sure.
Total difference.
Yeah.
So, oh, so I'll take a breath
Yes.
and we will find a new
Let
case to talk
yes,
about
we'll
next
we'll
week.
we'll let go of Cockygate and find something else scandalous
Yes.
to talk about next week.
We wish you all peace. We wish
Yes.
everyone peace and happiness and all parties involved. Hopefully, you've moved on from this and are feeling better
Yes.
about life now. Um, and because at the end of the day, we're all just trying to do the thing,
Yeah.
right?
And now Kevin and Jennifer and Tara have a really awesome party story to tell.
That is true. That is true. Remember that time? And until next time, this is For Fuck's Sake.